It's my absolute pleasure to be inviting Bill again. Honestly, this conference and summit today would not be here without Bill and his research. So it's really fantastic to have him with us. Bill Yoder has been around the MUN scene for a very long time. You have told me when your first one is. I've forgotten now. But what's important?
1970.
Wow, 1970. Okay, yes. So here, best part of almost half a century now, and with us to discuss essentially our key topic, which is this summit about the rule of law. So, Bill, without further ado, I leave it over to you. To all of those with questions, we have the Q&A function here, and for those of you that streams, we will get your questions and put them in. So, Bill, over to yourself. Thank you for joining us.
Thank you very much. It's really a pleasure to be here on this auspicious anniversary of Model UN. I'm sure you've heard much about the rule of law yesterday and today with all the different speakers. And so I wanted to focus your attention on, if you're doing Model UN, what are the different options you have if you want to incorporate a focus on the rule of law in a conference? What are the different options? So that's what I want to cover today. So the first thing that I want to establish is the importance of the rule of law to the establishment of the UN itself. If you read the preamble to the UN Charter, you find that there are 4 pillars to save succeeding generations from the scourge of war, which twice in our lifetime have brought untold sorrow to mankind, to reaffirm faith in fundamental human rights and the dignity and worth of the human person, in the equal rights of man and women, and of nations large of small, and the third one, which is most important, to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. So this sets right out from the very beginning of the UN Charter that the rule of law is fundamental to the United Nations, to the establishment of the United Nations. And the last one, to promote social progress and better standards of life in larger freedom. Each of the pillars are intricately interrelated to each other. You can't have one without the other, but the rule of law is one of the fundamental foundations of the United Nations. So it is something that should get a lot of attention within Model UN. So there are basically 3 different areas in which you could incorporate a focus on the rule of law in Model UN. The first is very simply to focus on the rule of law as a topic. The second is to simulate a UN entity that is involved in or authorized to make legally binding outcome documents. The reason why I refer to them as outcome documents is because Model UNs are very used to drafting and adopting resolutions, but there are many other kinds of documents within the UN system that get adopted on a regular basis other than just resolutions. And finally, the third option you have is to explore the rule of law by simulating an international conference that drafts an international treaty. I'm going to go over each of these options in more detail during my talk. So let's look at the first one, the rule of law as a topic. The first obvious place to explore the rule of law as a topic is by simulating the GA 6th committee, which is the legal committee. You will find on the agenda of the General Assembly every year an item entitled the rule of law at the national and international levels that is always allocated to the 6th committee. It was first included in the agenda of the 61st session of the General Assembly at the request of Liechtenstein and Mexico. So again, it only first became a formal part of the UN agenda during the 61st session, which is not that long ago. The Assembly requested, as a part of that resolution, that the Secretary General submit an annual report on United Nations rule of law activities. And that is something that the Secretary General now does every year. So you can actually read the report that's submitted by the Secretary General as a kind of background document where the activities engaged in by member states with regard to this important agenda item is summarized. There have been a lot of resolutions adopted on the rule of law, beginning with the 61st session, and I've listed them all here. You can find a list and a link to all of these resolutions by going to the annotated provisional agenda of the General Assembly. Every year, they publish an annotated provisional agenda where they provide information about every item on the General Assembly's agenda, and they summarize the history of that agenda item and provide links to very important resources on that topic. So, for instance, in the 77th session, that would be, the document number would be A/77/100. The number 100 is very important because that is always assigned to the annotated provisional agenda. You have a provisional agenda which just lists the topics, but the annotated agenda is the document you want to look at because that provides a history of that agenda item. So all of these documents that I've listed here, actually, I took from the annotated provisional agenda. And if you were to go to that, you would find a link. You just click on that link and go directly to each of the resolutions that have been adopted on this agenda item. Other resources you will find in the annotated agenda include the report of the Secretary General. The report is called On Strengthening and Coordinating United Nations Rule of Law Activities. The most recent one is A/77/213. You will also find interesting summary records of meetings that have taken place in the Sixth Committee during the prior session. So, for instance, if you go to the annotated provisional agenda for the 77th session, you will find a link which will bring you to all of the summary record of all of the meetings that have been held in the Sixth Committee on that agenda item. And here I've given you the agenda item, which you could look up if you were interested in that. You will find a link to the most recent report of the Sixth Committee, where it summarizes all of the work, and one of the things you'll find in there is a summary of the work on that particular agenda item. And you will also find a link to verbatim records of plenary meetings in the previous session where that agenda item has been discussed. Now, you'll notice that records of the Sixth Committee are always summary records. In other words, they provide a summary of what was said. It's a much shorter document, whereas if it is discussed in a plenary meeting, the record will be provided will be a verbatim record. So it will be a record of exactly what was said by every person, every ambassador, the president of the General Assembly, whoever was given the floor to say something. You will find a verbatim record if it was a plenary meeting. Now, I want to make it clear, because we're talking about the rule of law, right, that if resolutions are adopted within the General Assembly, those resolutions are not legally binding. They are nothing more than recommendations. So if we look at Article 10 in the UN Charter, it says very clearly that the General Assembly may discuss any questions or any matters within the scope of the present charter and so forth, and may make recommendations to the members of the United Nations or to the Security Council or to both on any such questions or matters. So even if the Sixth Committee adopts a resolution on the rule of law, that resolution is nothing more than a recommendation. That resolution is not legally binding. None of the resolutions within the General Assembly are legally binding, and there's a very good reason for that. When the UN was created in 1945, the great powers that won the war wanted to make sure that other countries, small or less powerful than them, could not impose decisions that they did not agree with. And so, in order to respect the principle of sovereign equality, where every country has the same legal rights, They stripped all of the organs of the UN, except for the Security Council, we're going to get to that in a moment, of the ability to enforce their decisions. So none of the decisions adopted by the General Assembly or ECOSOC or the Human Rights Council or any other part of the UN system is legally binding. Those resolutions are nothing more than recommendations, and that applies to the Sixth Committee as well. Now, Security Council is the exception to the rule, as I just mentioned. It is the only organ that is authorized by the UN Charter to make its decisions legally binding. That doesn't mean that every resolution adopted by the Security Council is legally binding. It means that it has the power to do so. Because these decisions can be legally binding, the great powers who stripped all the other organs of the ability to enforce their decisions gave themselves the veto power to prevent other countries from imposing decisions that would be legally binding upon them that they did not agree with. The veto power is not necessary in other organs of the UN, again, because those decisions are nothing more than recommendations. But in the Security Council, which has the power and is authorized to make decisions legally binding, they protect themselves by giving themselves the veto power. So there are 5 permanent members of the Security Council that have that power. Now, I'm not going to go into all the intricacies of this, but there are many proposals every year. There's an intergovernmental organization, intergovernmental body within the General Assembly that meets every year to discuss reforming the Security Council. The veto is, of course, one of them. That's been discussed for years. And obviously, no changes could be made to the Security Council without the P5 agreeing to it. So that is, it's something which is still very controversial to this day, and is a matter of much discussion every year at the UN. But no one anticipates that there'll be any changes anytime in the near future on the veto power. Now, what makes a Security Council resolution legally binding? This is something that is very critical to understand if you are simulating the Security Council, which is very popular in Model UN conferences. Most Model UNs are not aware of what makes a Security Council resolution legally binding, or how to make a Security Council resolution legally binding that they may be drafting. Now, there is no agreed form of words to make UN Security Council resolutions legally binding. And over the last decades, now more than 7 decades, the Security Council has been inconsistent in this practice. But I'm going to talk a little bit about how to do that. 1 second here. So some maintain that in order for a Security Council resolution to be legally binding, it must invoke what's called Chapter 7 of the UN Charter. Chapter 7 states that the UN Security Council is granted the power to maintain international peace and security. It allows the Council to determine the existence of any threat to the peace, breach of peace, or act of aggression, and to take military and non-military action to restore international peace and security. So this is where the Security Council resolutions have the ability to become legally binding because they are authorized to address the existence of a threat to peace and also to take military or non-military action in the form of sanctions, for instance. And we've seen that today on the international stage in a number of different ways. Now, in order to make it clear that a resolution is legally binding, a resolution should contain the following 3 elements. It should mention that whatever act of aggression is being addressed, that it is a threat to international peace and security. That's the first element. The second element, and this is usually done, not always, but usually done in the last preambular paragraph, it usually states very clearly that it is acting under Chapter 7 of the UN Charter. Now, if that is inserted into a Security Council resolution, that makes it crystal clear that this is a legally binding resolution. And we find in the operative paragraphs that the verb decides is used in a number of different ways, or a number of different to the first verb that begins an operative paragraph in these resolutions. So again, these three elements stating that the issue that's being addressed is a threat to international peace and security, stating that the Council is acting under Chapter 7 of the UN Charter, and references in the operative paragraphs, beginning those paragraphs with the words decides, makes it crystal clear that this is a legally binding resolution. Now, it's important to understand that it is not absolutely necessary for these three elements to exist in a resolution for it to be considered legally binding. What I am saying is that if the members of the Security Council want to remove any bit of ambiguity, whether it is legally binding, these three elements are included, but they are not necessary. Sometimes you will find in resolutions that there are just two of these elements. Sometimes you will find in some legally binding resolutions that these three elements are not present at all. And there are certain reasons for that, which we will get into. So here's an example from a resolution adopted in 2011 on Libya. I wanted to give you, I don't know if we could make the screen a little bit bigger so we can see the text a little bit better. But what I wanted to do is I wanted to show you that if you look at the preambular paragraphs at the bottom of the page, just before we get to the first operative paragraph, which begins with the number 1, it states, and I'm having a little hard time seeing this without my glasses. It states,
I could read it if you'd like.
yes, thank you.
Demands the immediate establishment of a ceasefire.
No. I'm looking at the last two operative paragraphs.
Oh, the last two operatives.
The last two preambular paragraphs. There are no numbers.
So determining the situation in the Libyan Arab Jumeirah continues to constitute a threat to international peace and security, and, as you say, acting under Chapter 7 of the Charter of the UN.
No, but the paragraph before.
The second to last says determining the situation in the Libyan Arab Jumeirah continues to constitute a threat to international peace and security. And then the last preamble says acting under Chapter 7 of the Charter of the UN.
So what I want to show you is that this is a classic resolution, the Security Council resolution that is crystal clear, that is legally binding. It includes the first element that establishes that it's a threat to peace and security. And the last preambular paragraph makes it crystal clear by saying that they're acting under Chapter 7. And then you will find in that resolution in the operative paragraphs that the word decides is used in multiple ways as well. Now, the absence of one of these, they're considered best practices, means that one or more of the P5 members has resisted inclusion of that element in order to retain constructive ambiguity regarding the effect of the resolution. So if one of the P5 during the negotiation process wants to leave the door open to potentially claiming that it is not legally binding, during the negotiation process, they will have, and there have been instances in the past history of the Security Council, they will have argued against including all three elements so that it leaves room for ambiguity for whether or not you can make an argument that the resolution is legally binding or that it's not legally binding if they do not contain all three elements. After the use of force by the United States in Iraq and Libya, Russia and China have been particularly reluctant to include any reference to Chapter 7 in order to avoid giving the US any cover to use military force. So this is a very, very important transition following this particular incident in world history. And if you are simulating the Security Council and dealing with a particular conflict, and you are representing Russia or China, you need to know about this history during the negotiation process. If in fact there is the proposition, let's say by the United States or to include a reference to Chapter 7, nowadays Russia and China would resist including those references. So again, this is an important part of the rule of law and understanding how it impacts a resolution that might be adopted by the Security Council. Now, is invoking Chapter 7 necessary for Security Council resolution to be legally binding? The answer is no. Articles 24 and 25 of the UN Charter state that any decision of the Security Council is legally binding upon all UN member states and is not contingent upon the Council's acting in exercise of its Chapter 7 powers. So in those instances where it does not invoke Chapter 7, the key question is in determining whether a particular provision in an operative paragraph, whether the decision if a decision is taken in an operative paragraph, determining whether the Council has chosen to use words that indicate its intent to create a legally binding obligation. So what we find here is that if there is no particular reference in a resolution that it is acting under Chapter 7, it can still be legally binding, but there's also much more room for interpretation about whether it is legally binding or not. So you really have to analyze the words that were chosen to be included in a resolution to make that determination. And it's not always easy to do so. And again, the ambiguity sometimes is on purpose so that it makes it difficult. Now, in 1971, there was this case that was brought before the ICJ. A resolution that was adopted in the Security Council, Resolution 276 in 1971, which had been adopted without a textual indication that the Council was acting in exercise of its Chapter 7 powers. So the question was brought to the ICJ to determine whether or not it should be considered legally binding on member states. And they ruled the following. They said it has been contended that Article 25 of the Charter applies only to enforcement measures under Chapter 7 of the Charter. It is not possible to find in the Charter any support for this view. So they're saying very clearly that it does not have to reference Chapter 7 in order for it to be legally binding. They go on to say, in view of the nature of the powers under Article 25, the question whether they have been in fact exercised is to be determined in each case, having regard to the terms of the resolution to be interpreted, the discussions leading to it, the Charter provisions invoked, and in general, all circumstances that might assist in determining the legal consequences of the resolution of the Security Council. So without invoking Chapter 7, you can see it becomes much more difficult to determine whether that resolution is in fact legally binding. And as I said, it is usually done on purpose to create that ambiguity. So when Chapter 7 is not invoked, there are no words which you can point to that clearly indicate that it's legally binding. As the ICJ indicates, you have to take a number of things into consideration. You have to consider what were the discussions leading up to the adoption of the resolution. You have to look very carefully at what words were used in the resolution, the circumstances in which those words are used to determine whether or not it is legally binding. Here's a very interesting example from 2013. And I want to go to so Philippe, if you can also do me the favor of
Sure,
reading,
sure.
reading again, the last two preambles of this
Okay.
resolution.
Yep. So the last two preambles say determining that the use of chemical weapons in the Syrian Arab Republic constitutes a threat to international peace and security. And the last reads underscoring that member states are obligated under Article 25 of the Charter of the United Nations to accept and carry out the Council's decisions.
Now, what do you notice about the last preamble before the operative section?
It seems a bit. It seems a bit of a stretch. It seems a bit struggling to force people to do what they want.
What,
Underscoring.
what, from what I said about what are the three elements that normally make it crystal clear,
Yeah.
what difference do we see here?
We're obviously not seeing Chapter 7. You know, we're
Yeah.
not seeing Chapter 7. We're seeing Article 25, which obviously, as you say, makes it a little harder to properly ascertain that it's legally binding. Of course, it's saying that it's trying to say that it is, but is it as strong as you said,
Now,
Chapter 7?
the interesting thing is that Article 25 says that the decisions taken by the Security Council are legally binding, right?
Yeah.
But then it leaves the ambiguity over whether this particular decision was meant to be legally binding or not. And it is highly unusual in a Security Council resolution to find Article 25 being invoked in place of Chapter 7. So it's a fascinating example within the Security Council's history of how they were struggling on this particular resolution with this issue. So the reference to Article 25 is very unusual. You do not, I don't know of another instance where this was used. I haven't gone through every Security Council resolution, but this is a highly unusual way to replace invoking Chapter 7 with replacing it with invoking Article 25. But it doesn't lessen the legally binding nature of the resolution. In fact, this resolution is considered to be legally binding. Even without the reference to Article 25, the inclusion of other elements, such as using the word decides in the operative paragraphs, usually suggests that it is legally binding. So, other language that indicates that a provision is legally binding without invoking Chapter 7 is the use of the word demands. Now, it's very interesting that the word demands can be used in two different ways in Security Council resolutions. It can be used to let's say there is something in international law which has already been recognized and adopted by the international community. A Security Council resolution can demand that a particular country abide by something that has already been established by international law. That is a clear way of invoking and making its own resolution legally binding. So one way is to use the word demand to command a country to abide by its obligations in already existing international law. But the word demand could also create a new legally binding obligation that does not yet exist in international law. So the two uses of demand, you have to be aware whether or not you're using it to point attention to something which is already considered legally binding, and you're just reinforcing that in a particular member state, you're demanding that they abide by that law. You can also use it to establish a new legally binding law that does not yet exist. And the best example of this is if you go to paragraph 2 in Resolution 1696 in 2006, where they say, demands in this context that Iran shall suspend all enrichment-related and reprocessing activities, including research and development, to be verified by the IAEA. So this is not something which had already existed prior to this resolution, but this is an example of how the members of the Security Council We're making it clear that in their resolution, they're creating a new legally binding standard. Now, let's look at there's a special case. And remember I said that in GA resolution, so I finished anything about the Security Council. If anybody has any questions on that, please ask it now, because now I'm going on to something new. But I want to come back briefly to the General Assembly, because I did say that General Assembly resolutions are nothing more than recommendations. However, if we look at the fifth committee, which deals with administrative and budgetary questions, they approve the budget for the UN. Budgets adopted by the fifth committee are considered legally binding. Now, that may contradict what I said before, that all GA resolutions are nothing more than recommendations. However, you must keep in mind something very important, that it is not, even though it creates an obligation of all member states to pay what they have been assessed in order to pay for the programs which have been adopted by the General Assembly. The budget of the UN is not legally binding in the sense that they don't have a power to impose penalties or sanctions if a country chooses not to comply. So this is very important. It's a kind of gray zone here. It is legally binding, yes, that they're obligated to pay for the budget, but if a member state chooses not to comply, there's no way of imposing penalties or sanctions. It is the case that if a member state does not pay its dues for 2 years consecutively, it loses the power to vote until those dues have been paid up. But still, there are no other penalties or sanctions that the General Assembly has of enforcing something like this. So let's talk about another example of, we're no longer talking about focusing on the rule of law as a topic in the sixth committee. We're now talking about how to incorporate the rule of law by simulating UN bodies that are involved in drafting legally binding conventions or treaties. Two examples that I want to focus on are the International Labor Organization and the World Health Organization. Now, the ILO is one of my favorite specialized agencies. They were actually created in 1919, at the same time that the League of Nations was created. And they're well over 100 years old. And when the UN was created, they became the first specialized agency of the United Nations, but their existence goes back all the way to 1919. And they are quite unique in the sense that they work on what's called a tripartite social dialogue format, where workers, employers, and governments together make decisions on establishing labor standards. What makes this different from all other entities within the UN system is, in other UN entities, it is always governments that have the unique power of adopting and drafting resolutions. We won't get into all the nitty-gritty details. Yes, you can have NGOs that have the ability to make statements, but they cannot participate in the actual adoption of outcome documents. In the case of the ILO, governments are not making decisions on their own. The decisions are made equally by workers, employers, and governments together. So this social dialogue thing, which goes all the way back to 1919, is quite unique and quite fascinating. And they are very much involved in establishing labor standards, which are legally binding on member states. So this is a regular activity that the ILO engages in, which makes it a really interesting entity to simulate if you want students to gain experience in the negotiation process in establishing legally binding laws. Now, the process of adopting international labor standards is quite lengthy. So you would not, in the case of a Model UN conference, be able to simulate all the different steps leading up to the establishment of a international or legally binding international labor standard. But you could include it by simulating what's called the Standard Setting Committee. In each international labor conference, there are multiple committees that meet on a regular basis. One of them is the Standard Setting Committee, and this is the committee which takes the lead in drafting and adopting new conventions that establish international labor standards. Now, as I said, there are many other steps leading up to that. There is another committee called the General Discussion Committee, which is charged with discussing issues of importance to the ILO that sometimes, following a General Discussion Committee, which adopts what are called agreed conclusions, not resolutions, agreed conclusions. Sometimes the next step is to recommend that the ILO adopt international labor standards regarding an issue which first was discussed in the General Committee. So before something gets to the Standard Setting Committee, there are a number of other steps that must occur. But in the case of a Model UN conference, you don't have to simulate all of the steps leading up to it. You can go right to simulating the Standard Setting Committee. And one thing that we have done in the conferences that we organize at WFUNA is one year we did a simulation of the Standard Setting Committee in drafting and adopting a convention on harassment and sexual violence in the workplace, which was a fascinating experience. It's as I said, a great opportunity for learning about the negotiation process involved in establishing the rule of law. I cannot, obviously, in the time permitted, go through all the steps of how the simulation of a Standard Setting Committee would be different than other simulations done at the UN. It is quite different. It is not the same as drafting and adopting resolutions, but it is something that you could simulate as a way of gaining knowledge and understanding and experience with establishing new labor standards. The WHO just recently published a draft of the first legally binding treaty intended to ensure that vaccines, drugs, and diagnostics are shared more equitably around the world during the next pandemic. So this is another body which is very much involved in drafting and adopting legally binding treaties as well. This is not, I would say, it is not a common activity that they would engage in, but it's just another example of how there are other UN entities that are involved and can be involved in these sorts of activities, and they could be incorporated into a Model UN conference. Now, drafting conventions and treaties. You must understand that it's very different from the process of drafting resolutions. It's more complex, much more complex than drafting a resolution. So it involves, you can't simply, if you've never done it before, you can't simply assume that your experience in organizing Model UN conferences where the focus is mainly on resolutions, that you can just simply apply that to the negotiation of conventions and treaties. You need to understand and study and learn about those processes and how they're different from the process of drafting and adopting resolutions. I will go over some of those differences just to give you some of the differences involved in it. But it is a more complex process and involves more attention and would involve more training prior to a conference in order for the delegates to be up to speed. One of the examples that I want to focus on is the inclusion of different types of provisions, something called flexibility clauses. One other thing that I just want to point out, in Model UNs around the world, they use the word clauses when they're talking about the different components of resolutions. And resolutions, as I said, are not legally binding documents. And clauses are used when talking about legally binding documents and not documents that are not legally binding. So it is at the UN, when we're talking about resolutions are comprised of paragraphs, not clauses. The term clauses would be appropriate when you're adopting and drafting legally binding documents like treaties and conventions. But in the case of drafting and adopting resolutions, it is not appropriate. And it is done all over the world. Every Model UN conference I've ever gone to, they refer to them as clauses. And just for your information, that is totally inappropriate, because most Model UN conferences are not aware that their resolutions are not legally binding. They're nothing more than recommendations. And because of that mere fact, you cannot refer to the contents of a resolution as being made up of clauses. So what do I mean by flexibility clauses? In the negotiation of a convention, which, let's say in the context of the ILO or in an international treaty, you will often find something that we refer to as flexibility clauses. So if we take the ILO, for instance, you'll find that it contains clauses that allow for the gradual implementation of certain requirements. So certain countries, in order to make it easier for them to agree to sign a convention, the ILO recognizes that some countries may need more time, for instance, in order to make changes to be able to implement certain aspects of a treaty or convention, or they realize that there are different laws in different countries, and I'll give you some examples here, which would make it difficult for them to establish or to sign on to a treaty which is not aligned with the provisions of laws already established within a particular country. So to make it easier for countries to agree to sign a convention or a treaty, they include what are called flexibility clauses. So let's look at an example. So if we look at the Fishing Convention, which addresses what the minimum age should be, what minimum age should be required to work on a fishing vessel, because fishing vessels are quite dangerous, right? And we don't want young children working on a fishing vessel where they could easily get injured. So they established certain age requirements. So here in this convention, they said the minimum age for work on board of a fishing vessel shall be 16 years. However, the competent authority may authorize a minimum age of 15 for persons who are no longer subject to compulsory schooling. So it's acknowledging the fact that in different countries, they have different age requirements of how long children must go to school. In some countries, it may be only up till the age of 15. In other countries, it may be even longer than that. So they're acknowledging the fact that every country may have a different compulsory age, and that if somebody lives in a country where the compulsory age is only 15, that they should be allowed to work on a fishing vessel because they're no longer obligated to continue their education if they don't want to. So here they're saying the minimum age should be 16, but if you live in a country where the compulsory education ends at 15, that somebody from 15 on should be allowed to work on a fishing vessel. The flexibility clauses on the minimum age leaves room for an exception to be made, and also goes on to clarify the conditions under which a 15-year-old may work. The competent authority, in accordance with national law and practice, may authorize persons of the age of 15 to perform light work during school holidays. In such cases, it shall determine, after consultation, the kinds of work permitted, and shall prescribe the conditions in which such work shall be undertaken and periods of rest required. So they're acknowledging the fact that even if a 15-year-old is granted permission to work on a fishing vessel, there are certain types of activities on the fishing vessel which they should not be allowed to do because they are quite young and might be dangerous for them to engage in. So here's an example of how a particular clause in a convention on fishing makes room for the fact that there may be differences between countries and makes it easier for countries that either have different compulsory ages of education, where it may allow individuals who are 15 and older, but that they're making it very clear the preference should be 16 and older, but they're leaving it open for youth 15 and up to be able to work in a particular country. So flexibility clauses are really, really important to understand when you're negotiating legally binding entities. The last category that I want to focus on is you can simulate an international conference whose aim is to draft an international treaty. Now, this is a third category because it's not simulating an entity like the ILO or the World Health Assembly, which engages in drafting and adopting legally binding conventions or treaties. There are sometimes the General Assembly will call for the establishment of an international conference to draft an international treaty. So it is not a treaty which is drafted by the General Assembly, but the establishment of a conference may be called for by the General Assembly. So, for instance, the Conference of the Parties of the UNFCCC, which deal with climate change, is a prime example. We will now be having the 28th conference in November in the UAE on climate change. And you are all probably familiar with the peace agreement, the Paris Agreement, which was adopted in one of the COPs, which is considered a legally binding document. Now, it does not mean that that every COP establishes a legally binding agreement. That is not the case. But much like in the case of the Security Council, they can adopt or agree to adopt a legally binding document. But I want to get into a little bit about how language is manipulated to create ambiguities in how to interpret what is and is not legally binding. Much like in the Security Council, we saw how they have ways of inserting ambiguity in the language to make it, to leave room for one member state to argue against another member state who wants to say that it's legally binding or not. Another example is just recently, earlier this month, the UN adopted the first ever maritime biodiversity treaty, which took years to negotiate. So sometimes these treaties take very long, and I would not suggest simulating an intergovernmental conference, which takes 8 years to be negotiated.
Might be a bit long. Might be a bit long, I would say.
It's possible, right? You could have people.
We did it at my university at KU Leuven. We did a simulation of BBNJ.
Yeah. How long?
I was the US. It was 2 full days of debate.
Okay.
And in classic US fashion, I threatened to veto, and we got our way. So,
but you could, and it's never been done. You could, in a Model UN conference, and I'd like to see this done, have something negotiated over more than one conference, so that you begin the negotiation process, and then you continue it at another conference.
Yeah, it's definitely
I would like
to
see something like that. Not over 8 years, but let's just do something over a 2-year period to show that sometimes these things take more time to do. In any case, the example that I want to say is that these treaties are sometimes negotiated outside. Their GA resolutions are adopted that call for the establishment of an intergovernmental conference or an international conference, and the COP, the Conference of the Parties of the UNFCCC, is one of them. Let's look a little bit about the language, manipulating the language. If we look at Article 4 of the Paris Agreement, we find something very interesting. In order to achieve the long-term temperature goal, in Article 2, it states that the goal should be keeping the average temperature less than 2 degrees centigrade. I mean, the increase less than 2 degrees centigrade, but optimally it should not be more than 1.5 degrees centigrade as a goal. So Article 4 says in order to achieve the long-term temperature goal set out in Article 2, which is keeping it below 2 degrees centigrade, but optimally at not higher than 1.5 degrees centigrade, partners aim to reach global peaking of greenhouse gas emissions as soon as possible. So this is from the Paris Agreement, which is considered legally binding. But what do we mean? What exactly is legally binding? Parties aim to reach global peaking of greenhouse gas emissions as soon as possible, right? What is legally binding in that statement? And then in Article 4(2), we say each party shall prepare, communicate, and maintain successive nationally determined contributions that it intends to achieve. Parties shall pursue domestic mitigation measures with the aim of achieving the objectives of such contributions. What is legally binding in this article? The word shall is a term which is used when you want to make something legally binding. But what are they saying each party shall do? They're saying they should intend to achieve or they should aim to achieve. Think about that. What exactly is legally binding if all they are maintaining is that each party should intend to achieve or that they should aim to achieve? So there are two categories of things that are legally binding. There are obligations of conduct and obligations of results. While these are binding obligations, they are obligations of what we call conduct rather than obligations of result. The term intends to achieve establishes a good faith expectation that parties should intend to achieve something, but they stop short of requiring them to do so. So what is legally binding is that they should aim to do something, but they're not required to do so. So the manipulation of this language, while we consider the Paris Agreement to be legally binding, we have to look at exactly what is legally binding. Paris Agreement doesn't really require very much other than member states should intend to achieve certain outcomes. They're not required to do so. So we have to be very careful when we say things are legally binding. What do we really mean by it? And the only way to determine that is by looking at the language that's used. So again, shall versus will. If we had, in some parts of the Paris Agreement, you'll find the word will being used instead of shall. Although the Paris Agreement sets standards for behavior, it does so in language that is predictive rather than prescriptive, and this just generates strong expectations rather than imposing requirements. So these are just some fine points that you should be aware of if you want to focus more on including the rule of law in your simulations. You have to understand the negotiations over the words that are agreed upon are often done with great effort and at times are purposely done to make those words ambiguous so that there is room for interpretation. And at other times, those words are very carefully chosen to make it seem like certain obligations are created without making them requirements. So these are all things that delegates need to understand through the training and preparation of the conference, because during the negotiations, this becomes a critical component of what they agree to or don't agree to put into a particular legally binding agreement. So again, I hope this has given you some things to think about how to include and focus on the rule of law in the Model UN conference. Again, you could focus on it as a topic. You could include an entity like the ILO, which is one of my favorite things, or the WHO, which are negotiating legally binding documents, or you could simulate an international conference, much like a COP, which is also involved in negotiating legally binding agreements. So I will end here in case there are any questions. I hope this has given you some introduction to what's possible and how to incorporate it into your Model UN conference. Thank you very much.
Thank you so much, Bill. Really appreciate it. You've got the claps coming in there. So there is one question that came through that was actually before we even started this. Actually, some delegate asked me, what is one thing you think delegates should do to be more aware of how present the rule of law is in the UN? If there was just one thing that you think would be able to improve the standards, because very often delegates honestly do not have either a legal background or much consideration for sort of the legal aspects of the UN. What's one thing you wish they did?
Well, you could familiarize yourself with the agenda item that is focuses specifically on the rule of law at the international and national level. The Secretary General's report, which is put out every year on the activities that member states engage in to promote the rule of law, is a critical document. I would say focus on the Sixth Committee and their discussion of this item on their agenda. But also keep in mind, and it's really important to remember, that resolutions generally, whether you're simulating ECOSOC, General Assembly, Human Rights Council, or any other part of the UN system, recommendations are not legally binding and are nothing more than recommendations, because that is something that I find that most delegates aren't even aware of. That what they're negotiating all the time in all of these conferences in the real UN have no legally binding status. So that's critical. And also, if you're doing the Security Council, which is very popular, educate yourself about the nuances in the language in what makes a Security Council resolution legally binding or not, because that could actually raise the level of it could make the negotiations more interesting if everybody was aware about the language which would make a Security Council resolution legally binding, and the level of ambiguity which we find in Security Council resolutions to allow for different member states to interpret whether it is or not.
No, indeed, that's very interesting. Yeah, no, for sure. We did have a question from the stream about the veto power formality. This is more of a, I guess, not a question necessarily about the rule of law, but and you outlined a little bit, but why is it so hard to change the veto power formality?
Very simply, because the P5 have the veto power.
Yeah.
And there's no way. They are the only ones that can change the veto power. So if they don't agree to any changes, no changes will be made. So and I tell you that this is something which is discussed every year within the General Assembly. There is a particular area of the General Assembly. It's called the IGN, which focuses on this. There are many proposals that have been put forth. Even some of the P5 have put forth proposals to modify the veto power. France is one of the prime examples. They have put on the table proposals to modify the veto power, which have not been accepted by the other P5. So here you have an example of a P5 that is willing to modify the veto power, but all it takes is one of the P5 not to agree to that and to veto a proposal by another P5. So our hands are tied on that.
I understand. I appreciate that. Well, Bill, I think we've come to the end of our session, but we'll start another session very soon. Thank you very much. And let me take this chance to thank again Wafuna and Wyman for their continual support. It was really great talking to you. Very, very informative session that is recorded and will be distributed. So it'll be available for anyone else to view it. So thank you very much again. And,
My pleasure.
We'll see you all very shortly for our next session on 80 years of MUN.
It's been great talking to you. Thank you.